Good morning. Welcome to our webinar series on coping with the legal challenges arising from the pandemic. My name is Angela Zhang. I'm the director of the Center for Chinese Law at the University of Hong Kong. This is the fourth webinar in this series, and in today's webinar, we will be assessing the risks and uncertainties with the ongoing COVID-19 litigations against China. Before our program starts, I would like to remind the audience that we will leave some questions for Q&A at the end. So feel free to type in your questions in the chat box, either in Chinese or English, and we will discuss them later, okay? And we are very pleased to have a guest speaker today, Professor Jack DeLeo from the University of Pennsylvania Carey Law School. Hi, Jack. How are you doing today?
Thanks. How are you?
Hi. I know it's quite late in America right now, and I really appreciate that you stay up so late to do this program with us.
Oh, my pleasure.
So we saw there are many complaints that have been filed in US court alleging that it was the Chinese government's initial mishandling of the coronavirus outbreak that had resulted in enormous damages for US citizens and its businesses. And most of these complaints were class action suits filed on behalf of private businesses and individuals. One have been filed by the state attorney general from Missouri. And the states of Mississippi and Florida have also indicated that they may file suits soon. So could you first tell us the main allegations of this complaint?
Yeah, they're a curious group of lawsuits. As you said, there are a little over half a dozen filed now, mostly private class actions, a handful by state attorneys general. Missouri's already filed, Mississippi's at least indicated an intent, Florida may do it. In a way, they're this curious combination of making some fairly standard tort claims, but applying them in a truly exotic circumstance, which makes the cases kind of tough. So if you look at what they're actually claiming as the basis for seeking a legal remedy here, a lot of it is essentially negligence law and tort. And the claim is that China, the state, or Chinese state actors, officials, laboratories, regulators, whatever, were careless, or worse than careless, perhaps reckless, perhaps intentional, in various stages of the saga of the coronavirus. Its release, perhaps from a wet market, perhaps on a less plausible theory from a lab, negligent or worse in failing to report in a timely fashion to the World Health Organization, in covering up the information such that the WHO did not get it soon enough and the United States did not get it soon enough. All of that then leads to this story, which you see in the sort of fact sections of these pleadings, a long list of what the allegation is China did wrong and perhaps malevolently wrong in a way that led through a pretty complicated chain of causation to physical health harms, economic harms, and emotional harms to people in the United States. So that's the core of most of the claims. There are a few others. There's some other tort claims that are in there. There's some rather imaginative notions of affirmative duties. That is, that China actually owed it to the United States to keep the supply of masks coming. That's an interesting argument. And you also get arguments that look a little bit to affirmative duties to report. And then you get some things which try to apply some strict liability torts, public nuisance, abnormally dangerous activities. And then we get those old favorites of the first year torts curriculum, intentional and negligent inflictions of emotional distress. So it's really the whole spectrum of tort issues, but again, applied to some very exotic facts. That's true of the private class action suits. The state suits often repeat a lot of that. And at least the Missouri suit is what is being framed what's called a parens patriae form, which is the state suing on behalf of its citizens. But the state is also making claims for the harm to itself. And these are not conventional tort harms. They're a bit more indirect. They're things like harms to the state budget from having to pay out unemployment claims or having to provide more public welfare services and health services, or even the loss of tax revenues from the economic shutdown that's occurred due to the coronavirus. So, the legal claims really take that form. Again, some pretty standard legal ideas, but stretched to try to fit some pretty unusual facts.
Right. I see. So we know as a general principle under international law and also under US domestic law it's really difficult to sue a foreign state. I mean, it's mostly based on the doctrine of reciprocity, because if America allowed this kind of lawsuits against other countries, then other countries might retaliate, and this will expose US citizens and its assets to legal risk overseas. But I do understand that under the US Foreign Sovereign Immunity Act, there are some limited exceptions. And do you think, any of these complaints that you just described, do they fall within those exceptions?
Well, it's a bit of an uphill struggle. It is tough. As you say, it is tough to bring suits against a foreign sovereign. And by that, we mean not just the state itself, but what US law calls its agencies and instrumentalities, which means all the agencies of the state. It can include, a regulatory body. It can include whoever's supposed to do the reporting to the WHO. It probably includes the lab, which appears to have been primarily a state lab. And actions that the state takes through its various agents. So who counts as a sovereign is pretty broad. It also includes wholly owned state corporations. And you're right to say that reciprocity is the idea behind sovereign immunity. Indeed, the famous American case on this happened right here in Philadelphia. The Schooner Exchange, this French formerly American French ship, comes into the harbor, and the court agonizes over it and says, well, look, we don't know what to do about this, because on the one hand, courts should be able to bring anybody in as a defendant. On the other hand, there's something insulting about making a foreign state a mere party in another state's courts. What do we do? And the ultimate answer was, well, reciprocity. That is, I would rather not have my courts have jurisdiction over your state than to have me be subject to jurisdiction in your courts. So that reciprocity story is there, but at this point in the United States, it has been fully codified. Since the 1970s, we've had the Foreign Sovereign Immunities Act. It's actually a subject matter jurisdiction statute of all things, even though it sounds like it's personal jurisdiction. But basically what it says is that foreign sovereigns are immune under what international law would call the restrictive theory. That is, they're immune when they're doing things that are distinctively sovereign. They're not immune when they're doing the kind of things that a private actor could do. And that's what's going on in these cases. But it is tough in general, and it's especially tough on the kinds of facts alleged here to fall within those exceptions. So there are a couple of big ones that track this customary notion of limits to sovereign immunity. And one is the so-called torts exception. And it says basically a sovereign, a state, and its instrumentalities are not immune if they've committed a tort that's kind of like something anybody else could do. So when we talked about negligence and abnormally dangerous activities, all of that sounds like something private actors can do. And the basic idea here is that if the embassy driver runs over your foot, you can sue the foreign country, right? So that's pretty much ordinary torts. But once you get out of the ordinary tort and you get into a case where the harm is caused by the negligent or reckless or even willful policy choices, bad policy choices by the foreign government, then it falls into what American law calls the discretionary function exception. So you get your immunity back when it's not, an ordinary tort, but it's a policy choice, even a really bad one. So that's one problem, and a lot of what's at issue here does seem to fall in that range of bad policy choices that are being alleged that China made. Another piece of that exception, though, is under US law, the immunity is lost only if the tort occurs in the United States. And courts have interpreted that to mean something close to occurring exclusively in the United States. So it's not enough that the harm, the consequences happen here, at least some of the tortious actions have to happen here, and that's tough too. There are some other areas where you can lose immunity in torts. There are a handful of cases that say when a government behaves really, really badly and in a way that is distinctively governmental, the state behaves that way. For instance, assassinating a political dissident who's fled the country. Sometimes the courts will say, okay, you don't have discretion to do that. That's not within the policy discretion, so you lose immunity again. But again, even on the most extreme allegations about what China did, unless you think it was an intentional release of a bioweapon or something that's pretty fringy like that, then it's hard to see something that gets you into that kind of egregious behavior. So that's the main exception, the torts exception. There's a second big exception, which is called the commercial activities exception. And the idea here is if a sovereign's making a contract, breaking a contract, that's just like an ordinary company, issue bonds, default on them, whatever, and so no immunity. But the problem here is there's very little commercial activity that's at stake in these cases. I mean, there's a little bit with the selling of personal protective equipment, perhaps, but there the main complaint is the government stopped the export, not that the company was engaged in price gouging, except under the shadow of government control. And the rest of it, the failure to report to the WHO, the stuff that's going on in the labs, whatever, that's just not commercial in any meaningful sense. The other issue with this exception is the commercial activity in question, the commercial activity connected to the case, has to either occur in the United States or have direct effects in the United States. And here, the chain of the links in the chain from what happened in China to the harms in the US is hardly a direct effect. Now, there are a couple of less traditional exceptions to sovereign immunity that aren't part of the general international law that US tracks here, and they're basically terrorism exceptions. And so US law has adopted, and this is also plausibly consistent with international law, which is very negative on terrorism these days. So one exception says, you lose your immunity for acts of terrorism if you are a designated state sponsor of terrorism under US law. Well, that's a list with like North Korea, Iran, Sudan. It's not China, and China isn't going to get put on that list. The other is JASTA, the Justice Against State-Sponsored Terrorism Act, which was adopted a while after 9/11, the terrorist attacks of September 11th. And that was designed to essentially take immunity away from Saudi Arabia for its possible role in those attacks. But that requires that the terrorist act occur in the United States, and that's got the same problem with where the terrorist act occurs. There's been there's one other wrinkle in this on sovereign immunity, which is that some of the suits have sued the Chinese Communist Party, and the party does not get sovereign immunity because it's not the state. But this is a bit of a problem too, because courts are a little skeptical of attempts to do an end run around sovereign immunity. You're really going after the state, and to say the state is controlled by the party, and therefore you're suing the party, that doesn't get welcomed very much. And beyond that, if you're going to go after the party, that's still one more remove. And now you've got to make an argument about how the state's relation to the party is kind of like a shell corporation in a corporate veil piercing context. Those are just all very, very tough cases to make out.
Right, I see. So to follow up what you have just described about the existing US legal framework, to what extent is it case law, and to what extent is the statutes? Because the reason I asked about this is because we all know that the United States is a common law country, and judges do have quite a lot of discretion in interpreting the law. So one of the things that China might be thinking about, is there any possibility a judge might find its way around this conventional construction of the exception to foreign sovereign immunity to enable this kind of lawsuits to be further pursued? What do you think of that?
Well, there are enough judges and enough courts around the United States that almost anything could happen. There are restrictions. I mean, this is the kind of case that is going to get appealed. And one of the purposes of adopting the Foreign Sovereign Immunities Act in 1976 was to take judicial discretion out of it, to take the politics in some sense out of it, and to make it a more judicially manageable thing. So you're right, the description I've given is partly statutory law, partly case law, but it's hard to work your way around some of those statutory terms. And in recent years, many of the glosses by courts have been toward more expansive immunity, not toward making states more subject to sue to the United States. Now, it's a little complicated because right now, as I'm sure all of our listeners know, attitudes in the US toward China are not super positive right now. So there is a sense that maybe this distrust or dislike of China could filter in. And certainly if you read the complaints and you read a lot of the political rhetoric in Congress and elsewhere, this is serious condemnation of China as essentially the evil empire these days. So that could do something. On the other hand, US courts don't really like dealing with cases which require them to go into the political minefield often, or where they have to get into the details of foreign law. And this kind of case is going to raise some nettlesome questions of Chinese law. Just how independent are these various actors from the state? Were there violations of Chinese law here? And that's just not something that the judges are real keen on doing. They do it enough that a fair number of people make a nice living as expert witnesses on that subject, but it's something that weighs, I think, against an expansive reading.
Right. So you agree there is a kind of a little bit risk, but it's still manageable.
Yeah, I mean, I think that there are so many. Well, obviously, to prevail as a plaintiff, you have to win on absolutely everything. Any break in that chain costs you your case, and we've talked about some of the weak links already, and I'm sure we'll talk about others. And you have to string all of those out for it to happen. I don't think the likelihood of prevailing is really high, but a lot of cases like this are not brought for legal victories. They're brought for the political point. And sure, there are class actions that are genuinely being brought by people who may hope to get some money out of them, although it's going to be tough. But the state attorney general suits, I think, are being done to make a political point. And at least one of the class actions is being funded, or being funded may not be right, but is being done in association with a quite conservative NGO. So you've got, there's definitely, these cases are definitely aligned heavily with the right wing of the American political spectrum.
Right. Yeah, I remember the first class action suit was filed by someone who used to be affiliated with Trump. So, and I do agree with you, maybe some of the suits were politically motivated, but I was also thinking about maybe they can also get some publicity out of this kind of lawsuits, because it's a very good, maybe from their perspective, is a good advertisement for them, because maybe it's very cheap to file a case like that. I remember the first, the plaintiff's lawyer said that it took him 24 hours to draft the complaint, and then it attracts like global attention. So I'm guessing maybe some of the indirect monetary benefits motivating this kind of lawsuits. Yeah. So let's go back to talk about these lawsuits. There are two types of suits. There are class action suits filed on behalf of private individuals and businesses, and there are suits filed. There is at least one suit filed by State Attorney General on behalf of citizens. And I have read some commentaries by some of the plaintiffs' lawyer in the past couple of weeks saying that the suits by the State Attorney General is quite creative. I don't know, what do you think about that comment? I mean, do you think the state might have a better chance of moving forward its suit than the class actions plaintiffs?
Creative is an interestingly double-edged word, right? It could be said somewhat tongue-in-cheek. I mean, they have made the right kinds of arguments if you're going to pursue this. For reasons partly we've discussed already, I think they face an uphill battle, and some of it is creative in the sense of stretching the boundaries of a lot of areas of existing law. The state class action, the state suits opposed to class actions, there actually is a fair amount of similarity among some of the complaints. Obviously they're telling the same factual story from the same perspective, but a lot of the claims even are the same. I mean, some of the class action suits get into the emotional distress claims, which are among the weaker ones. The state ones obviously have a little more firepower behind them in terms of how they're drafted, typically. But the state claims do have the problem that if you are the state suing on behalf of the citizens, that's a bit of a stretch. It's not suing in one's own interest. And so there are doctrines in US law that allow that somewhat, but it starts getting into essentially questions of standing. You're supposed to sue for your own interest, not on behalf of others. States have a special relationship with their citizens, but it's still a fairly narrow doctrine. And when the states are suing for their own interests, the impact on state tax revenues, the costs of providing welfare programs and such, now you're talking a very, very attenuated link, and it's a very hard claim to make. I think the state suits may stick around a little longer simply because the class action suits first have to get the classes certified, and that itself is pretty tough under current American law.
Right, I see. Yeah, now we are talking about the legal hurdles that these kind of plaintiffs will possibly encounter as they proceed the case. I mean, what are the other procedural hurdles you think that they might be met with? I mean, one of the things I was thinking about, the initial hurdle will be, how do you serve a foreign country? I imagine it could be quite time consuming, quite difficult to do.
Well, I mean, I wouldn't rely on the Hague Convention for the service of process in a case like this. It'd be interesting to see how the Chinese authorities would react to that. It sort of depends on which cluster of defendants you're talking about. I mean, the US does have sort of tag jurisdiction. And so if you think back to some of the other politically charged cases against China or Chinese officials, a lot of times these are mostly cases under the old Alien Tort Statute, which is another one of those areas where you see people pursuing private lawsuits not because they expect to get money, but because they expect a kind of political vindication. Somebody who claims, for instance, to have been a Falun Gong practitioner or leader who was jailed, or somebody who claims to have been required to do manufacturing labor in prison, things like that. They will bring those kinds of suits, and if Li Peng comes to the UN, or if Liu Qi goes to Salt Lake City for the Olympics, some service of process guy shows up and slaps them with a subpoena. So there are ways around this for some of the defendants. But I mean, I think that the more serious legal hurdles are things like, how do you certify a class action? I mean, the Florida case wants a class of 317 million Americans. It's just too big, and it's too diverse a set of claims, and even more narrowly structured ones have a very hard time, given how much the Supreme Court and others, actually legislative amendments too, have narrowed class actions. And there are all sorts of, I think, substantive law questions, as I suggested a little bit earlier. Some of these they make an interesting torts exam. I mean, they really are sort of stretching the limits of what you could plausibly claim. They're very robust notions of affirmative duties, the proximate causation questions. I mean, from what happens in China to what happens in the US, there's so much time and space, so many intervening variables, not least of which is what some would say is the unpredictably terrible response by the US government being partly responsible for the harms here. And it would be an interesting addition to the categories of abnormally dangerous activities or public nuisance to cover these. And then you've got the problem, at the back end, which is if it is about the money, how do you get it? China's not going to pay this. There are additional sovereign immunity problems, not with litigation, but with seizure of assets to satisfy judgments. That's another hurdle. So there's just a bunch of barriers. I could even see active state doctrine kicking up here. I mean, the U.S. has this justiciability doctrine, which says our courts won't sit in judgment of the sovereign decisions of another state taken in its own territory, and some of the lapses by China arguably fit that. So there's a whole bunch of ways that this could stumble.
Yeah, I mean, I already saw a question from the audience asking about enforcement. It was like, if in the very unlikely event that the Chinese government, lost the case, I mean, how could they possibly enforce this judgment against China?
Yeah, I mean, it's very hard to go after state assets. Now, some of the proposed legislation, which I'm sure we'll talk about later, specifically addresses that by stripping immunity from that as well. But it's not easy to go after sovereign assets.
Yeah, indeed. So at this point, we don't know how the Chinese government will respond to this lawsuit. We know they're very upset. I mean, we know the state media is that this kind of lawsuits were quite absurd, ridiculous. But we don't know what is the litigation strategy of the Chinese government. And in the past, we have seen foreign sovereign have taken different approaches with regard to this kind of lawsuits in the United States. I mean, some countries like Iran, Cuba, they decided not to appear in U.S. court, and then there were default judgment entered against them. Although they did lost the case, and there were a lot of damages awarded to the plaintiff, but because they have very few assets in the United States, and to the extent they have assets, they have been frozen. So the plaintiff doesn't really get anything. And now the plaintiff are trying to enforce the judgments in other countries, trying to seize upon Iran's assets in Europe. They file cases in Europe. And so it's very, very complicated. But there are other countries like Saudi Arabia, for instance, that choose to appear in U.S. court and defend the case. So it seems like different countries have different strategy, maybe because Saudi has more assets in the United States. But I'm just curious from a legal standpoint, putting all the political questions aside, as a matter of pride, maybe a country like China doesn't even want to appear. But just from pure legal standpoint, can you comment on the pros and cons for a foreign sovereign to appear in a court?
Yeah, well, you've mentioned two high-profile examples, Iran and Saudi Arabia. Well, China's not Iran. By the time we got around to sort of lawsuits against Iran, the relationship was broken. There was nothing really to damage there. And Iran is actually on the state sponsor of terrorism list, so it loses a lot of the deference, and in some specific contexts that were at issue litigation, the immunity and a lot of the issues with Iran, of course, were settled by a pool of assets following the hostage crisis. But China's also not Saudi Arabia. I mean, Saudi Arabia was specifically jurisdiction stripped by a bill, by JASTA, and some of the bills would do that specifically for China, in which case it becomes a little more similar. But I think China's had an interesting history with dealing with U.S. law of foreign sovereign immunity. One of the first cases to come up after the normalization of US-China relations in 1979 was the Huguang Railway Bonds case, where basically there were these Qing Dynasty bonds that had been issued, and American bondholders wanted the PRC to pay up. And China said, odious debts, ancient stuff, go away, and sovereign immunity. And of course, the plaintiffs came back and said, no, commercial activity. It's issuing a bond just like any corporation. And so, of course, we can recover. China did not show up. China did not defend in that case. It got a default judgment initially, and then it sort of got in a bit later with some help from the US government, and ultimately was granted immunity because the commercial activity exception didn't apply retroactively to the bonds in question. But China has since then gotten pretty accustomed to showing up in US court and making Foreign Sovereign Immunities Act claims. Now, usually it's something like, the Bank of China, before some of the reforms, had some state functions and commercial functions. It was pretty low-bore stuff. And there were these odd wrinkles like China thinks that state-owned enterprises are not part of the state, unlike US law, which thinks they are if they're directly owned. So, China could stick to its absolute theory of sovereign immunity, saying the state's absolutely immune, but those enterprises can be sued, and that gets you to the same result as US commercial activity exception does, calling the enterprises sovereign, but then stripping immunity because of commercial activity. So China's gotten kind of used to that and does show up and make these arguments. We've seen it in somewhat sensitive cases, like the Green Dam software cases, where these arguments will come in. But this one may be a little different. I mean, this is more politically charged in suing the Chinese state than anything I've seen that's gotten prominent enough to get wide notice. And it starts to sound a little bit like the South China Sea arbitration. China didn't show up even to contest jurisdiction there because it was just felt to be so, the Chinese view is so insulting, this is so inappropriate, and indeed so inappropriate encroachment on Chinese sovereignty that we're not going to dignify this with a response. Now, there are all sorts of differences. The bifurcation between jurisdiction and merits is less good in arbitration and all of that. But I think if the politics of it are that it's going to be tougher to show up and sort of say we're only talking about jurisdiction. On the other hand, if you don't show up, there's a real risk of a default judgment, and then that becomes its own big deal problem. If we had a different executive branch in the United States right now, I would think some of this might be handled with some sort of political pushback, but that doesn't seem to be where we're headed at the moment.
Right. Yeah, I agree with you because I also recently read a comment by a prominent litigator in Washington, Stephen Bogan from Jones Day, and then he actually suggested, like from a legal standpoint, it might be advantageous for China to defend its case because he can potentially request the court to consolidate all these cases through kind of like a multi-district proceeding. So it will be handled by a single judge and apply the law of a single appellate court. And this kind of reduce the risk of potential outlier judgment, as we just talked about. There might be a tiny little bit of risk out there. Who knows? A U.S. judge might find his way around this conventional, construct of the law. So
and it's completely standard in many legal systems, including the American one, to come in and contest jurisdiction, and then you can exit the case and potentially default there. But there is the politics and the optics of it are, if you are denying the legitimacy of the undertaking from the beginning, then there's something a little compromising sounding about showing up to contest jurisdiction. But I think that, as I've said in our discussion so far, I think they have a pretty good chance of a determination that there is no jurisdiction for sovereign immunity or failure to state a claim on which relief can be granted.
Right. So we covered quite a lot about the litigation right now, and then let's come back to talk a little bit more of the legislation. And based on what we have discussed so far, I understand that it's quite an uphill battle for the plaintiffs to move forward this lawsuit. And there is a recent commentary, and there's a recent interview with a plaintiff's lawyer called Sean Carter, who was the lead counsel in a massive lawsuit against Saudi Arabia on behalf of the families of the victims of the September 11 terrorist attack. And I think you were also featured in that interview as well. You were also in that post as well. And then he said something like, he agreed that it's extremely challenging for this kind of lawsuits to move forward. But however, he think that they could potentially be done. They could be litigated because, one example he gave is precisely the September 11 lawsuit. They started the lawsuit in 2003, and they weren't going anywhere. But after years of persistence, they were able to get Congress to act, and Congress passed the Justice Against Sponsors of Terrorist Act, JASTA, which you already mentioned, which created a new terrorist exception, which allows this plaintiff's lawyer to move forward their lawsuit. So they're still fighting a case in New York right now, after 17 years. So some of the lawyers were saying, maybe the real risk lies in Congress. And we did have seen some Republican lawmakers propose bills that trying to strip China of its immunity of being challenged in the U.S. court. So could you first tell us what these bills are? What do they want to do?
Well, there are about 4 or 5 of them now, and a little hard to count because sometimes you see very similar bills. But they all, in one form or another, seek to expand the exceptions to immunity, to strip China of immunity for the allegations in these cases, and it includes retroactively. That is, even though the laws would be passed now, they'd apply to the behavior with respect to COVID-19. They do it in a variety of ways. One would allow either private plaintiffs or a state's attorney general to sue in cases where a foreign state or its officials or agents recklessly acted or failed to act or failed to report information in ways that caused or substantially contributed to COVID-19 harms in the US. That's one version. Another version strips immunity from foreign states for tortious acts, even if they occur outside the United States, where they lead to harms in the US caused by COVID-19, again, specifically referencing the disease. There's another which would create a new exception to sovereign immunity and authorize suits against foreign states that intentionally or unintentionally release a biological weapon, and then it goes on to define biological weapon incredibly expansively, although it still might not reach even the lab theory of the far-fetched theory of genetically altered lab viruses, for any harms, again, relating to the harm U.S. Nationals or their properties. And then there's one other that takes the fairly straightforward approach of taking the tort exception to the sovereign immunity statute and says it applies to harms due to grossly negligent or worse misrepresentations to the WHO, which then leads to highly infectious diseases that cause harm in the US. A rare case of conservatives in the US Congress saying international law should be part of our law.
Right, I see. So I remember when JASTA was proposed, at that time, President Obama objected very strongly to the bill, precisely because of reciprocity, because it might expose U.S. citizens and its assets to legal risk overseas. But Congress actually overrode Obama's veto for the first and only time during his presidency. And Obama was quite upset, and he condemned this override as simply political, because in the months leading up to the 2016 presidential election, no one wanted to cast a vote against the victims of September 11th terrorist attack and in favor of Saudi Arabia. So given this political environment and the fact that there is a pending presidential election that will happen later this year, do you think, how likely do you think a similar bill might be passed by Congress?
I think it's possible. I wouldn't call it super likely. There's, a lot of really provocative legislation is introduced in Congress, including on foreign policy related issues, and most of it doesn't pass. And a lot of it is not even intended to pass. It's intended to make a point. And the JASTA legislation has a little bit of the story of, to use the American idiom, the dog that caught the car. I think there were a lot of people who wanted to vote for the 9/11 victims, but they really didn't want the law to pass, and oops, he overrode the veto. And even then it was watered down some. But I think you're right about the political context. That is, we had this long-standing pro-engagement consensus across Democratic and Republican partisan divisions here that basically, there were issues with China, but the idea was a generally positive, engaging relationship. That has flipped. And it started flipping 10 years ago, but COVID has obviously accelerated it greatly. And now nobody wins by saying, oh, China's not so bad. There's just very little room for that discussion. So in that sense, what you might think of as a Democratic opposition to the Republicans pushing this bill is undercut because nobody wants to look like China's friend right now, and especially in the context of COVID-19. On the other hand, the Democrats know full well that this is a diversionary tactic. Much of the politics surrounding blame China for COVID-19, some of it's about a genuine assessment of what happened, but a lot of it is about deflecting attention from the bad, the flawed US government response. And so Democrats, with a purely political calculation, can't be too enthusiastic to jump on board legislation that essentially serves Trump's and the Republicans' re-election agenda. In an ordinary world, you would see pushback from the president, maybe the way Obama pushed back against JASTA, because presidents don't like Congress constraining their discretion in foreign affairs. They don't like the foreign affairs headaches that come from what if another country decides to treat us the same way. We're all the way back to the schooner exchange ship in Philadelphia 200 years ago, when we say we don't do this, we don't hold foreign sovereigns to account in our courts because it so disrupts foreign relations. But I think if this got through Congress, sure, Trump would sign it. I think he's basically behind it, and it would be a short-term gain. Now, what would happen if it were on the books? By the time these cases move forward, we'll be into a new presidential administration. If it's a Democratic administration, you may see attempts again to use the considerable leverage the executive has to influence some of these cases in a way to claw it back some.
Right, yeah. I mean, I remember when JASTA was proposed, it created so much controversy, and not only within America, but also it prompted a lot of protests from U.S. allies and partners, and especially Saudi Arabia, who felt it was the target of the legislation and even threatened to sell off $750 billion worth of U.S. Treasury bonds that it held and its other assets, because it feared that its assets in the United States might be in jeopardy and might be subject to these litigations. And it did a lot of lobbying in Congress at that time. And as you described just now, I mean, the final JASTA bill was substantially watered down kind of at the very last minute, to the point that some of the legal experts saying that the bill was largely symbolic and it's toothless, because it's difficult to compel a foreign state to turn over its assets, so the plaintiff didn't really benefit materially from the bill. So given this political dynamics that you just described, do you think that even if, Congress passed a bill to facilitate this lawsuit, would it still be kind of toothless, because, there will be so much things going on in Congress? There will be Democrats, opposing, a real bill with teeth, so eventually it might be just something symbolic.
Well, I think, we don't know what the content is going to look like in the end. These bills differ significantly from one another. They are in their first draft proposed form. Who knows what they'll do. And and we're going to be very close to an election, so it all gets very funky. So how much impact any of these bills will have, I think, depends on content. We just don't know enough about yet. Now, one thing I will say, though, is that even if these bills go very far, if one of the more radical ones get through, which will raise some serious questions of international law, U.S. courts are going to say that's within Congress's power, they can do it. So in that sense, there's not going to be much pushback. But if an executive branch weighs in strongly against these going forward, that can have an effect depending on which aspects of the suit we're talking about. But the JASTA saga also tells you that even when you've got a law that does address the specific situation, once it comes out of the legislative sausage maker, it doesn't guarantee a lot of quick relief. I mean, 9/11 was quite some time ago. It's a couple of decades ago, and even JASTA was several years ago, and the cases are still working their way through, and some of their prospects for success do depend on cooperation from the U.S. government, and that would be an interesting question, depending on who's in the White House after January 2021.
Right, and talking about the White House, let's move on to our last part of the discussion about the administrative sanctions that the Trump administration is contemplating right now. I mean, some of we have seen in the press that the White House is thinking about various proposals, trying to hold China liable, and some of the proposals that are on the table include potential trade sanctions against China, or canceling some of China's holdings of U.S. Treasury bonds. or even seizing apparent assets of the Chinese state-owned enterprises, which sounds pretty scary. So what do you think, this possibly US measures against China, what kind of legal issues would it raise?
So a lot of the discussion, and it's again still fairly preliminary and pretty informal, but a lot of the discussion about actions the US government, the Trump administration, might take against China over COVID-19, outside the courts, obviously. There are a bunch of self-help measures, and they do raise international legal questions. So tariffs or other trade sanctions against China, well, if it's because of COVID-19, you got to cook up some way that's consistent with WTO. The WTO allows you to impose various kinds of trade restrictions, but it's usually for pretty narrowly economic activity. Sometimes it's about public health, but it's really about you're importing, beef that has ractopamine in it or something, right? It's not about this kind of thing. So there would be a WTO issue there. Interesting one. Of course, the WTO can't decide anything anymore because the US has hamstrung the appellate body. Selective default on Chinese-held US debts. I mean, that's defaulting on your bonds. That's a classic foreign sovereign immunity exception. That's, the commercial activity exception in its quintessential form. And that would mean international legal liability for the US unless there was some justification for it. And it would also be really tough to do. There's talk about not paying T-bills held by China. Well, the problem is T-bills are highly negotiable. China would dump them before the thing actually happened. It's just not. It would destroy markets. It would be an act of economic folly. If we're talking about expropriating Chinese state-owned property or state-linked, say owned by state-owned enterprises in the U.S., then that's an expropriation. And if it's not, if there's not fair and prompt compensation, that raises another international legal question. So all these are measures which, taken in isolation, would either be violations of international legal obligations owed by the U.S., or at least would be pretty colorable claims that they'd be violations. So then the question would have to be, are they justified as a response to some wrong that China has committed? And the WTO has its rules for that sort of thing. Some of the other things are more customary international law, but the US would have to articulate what that is. And that's a little tough. I mean, that's the kind of state equivalent, that is the nation level equivalent of the kind of claims we were talking about in the private suits. And frankly, we haven't seen much spade work, much laying of the groundwork of that from the Trump administration. The thing that gets the most discussion is the claim that China violated the international health regulations, the WHO rules on prompt notice of infectious diseases and potential outbreaks and that sort of thing. And plausible argument that China did, but if that's the case, then the link from that to these being the proper remedies becomes its own headache. And I don't see either the US or China submitting to binding arbitration or the ICJ or something like that on this. That would be probably the weirdest outcome of all, given both countries' history on that thing.
Right, I see. And so I remember the September 11 lawsuit started in 2003. And then 17 years later, they're still fighting their case in court. So I was wondering, so this kind of cases against China might potentially last a very long time. And I wonder, from your perspective, do you think this will have kind of like a long-lasting impact on the US-China relationship in the years to come?
Well, let me know if anybody's gotten any damage award by 2037. I think it is more symptom than cause. It's hard to imagine that these lawsuits and this proposed legislation would be happening were it not for the COVID-19 problem and the broader deterioration in the relationships. I really think they are more symptom than cause of problem in the Chinese and US-China relationship. And of course, it's a bit of a feedback loop, that is, they are not helping an already strained relationship.
Right, I see. Yeah, I agree. You are an expert on China and also on international politics, and I, as someone who really care about US-China relations, and now they're facing like the toughest time, maybe in the past 40 years. This is the lowest point right now. And do you see any prospect for the two countries to come to kind of like a peaceful resolution with each other? Regard to this COVID-19, litigation, I just don't know whether there's any creative proposal that could kind of ease the tension a little bit. What do you think?
Well, I mean, I think it'll be a peaceful resolution in the sense that I don't think we go to war over this, at least. So I guess that's a silver lining. I think these cases these cases and the legislation may sort of die a natural death for the reasons we've been talking about, and that'll help at the margins. But I don't think it gets at the more fundamental problems in the relationship. Now, that said, in Washington, there's a lot of talk about the new Cold War, and China's the new Soviet Union, and the Trump national security strategy lumps Russia and China together as status quo challenging rival powers, revisionist powers, all that sort of thing. But it is different. I mean, because for all of the many, many troubles in the relationship, the US and China are deeply interlinked economically, socially, and otherwise in a way that the Soviet Union and the United States were not. So there is certainly bad stuff there. And certainly compared to the baseline of not too long ago, things are a lot worse. But some of those things were going to happen anyway. Structural power shifts matter. The patience in the U.S. with a lot of the irritations and problems in the relationship, particularly on the economic side, has run out. So it's going to be something of a downturn. I don't think, though, it is inevitable that it is as bad as it is now. We may see somewhat more stable approaches. And I think if we get a very different US administration that's a little more inclined to cooperate with allies, you could see a more stable, perhaps more moderate approach, but certainly one that might have more of an impact on China, because it would be the sense that the US is off on its own agenda.
Right. I see that we now have about 15 minutes, and our audience are very enthusiastic and raise so many questions that it's almost impossible for me to keep track of right now. But I saw a familiar name among the audience, and actually, this is for my colleague, Johanna Chan. I actually bumped into him. Yeah, I bumped into him this morning. I said, you have to come to my webinar. And then so he did raise a question. Great. So let me start the question with Johanna Chan from my colleague and professor at University of Hong Kong. He said, suppose someone does file a case in US court. I agree that would be numerous procedural hurdles, but who will be defending the case? What would China do? Would she be risking submitting to jurisdiction by appearing in US court? We kind of discussed a little bit about this. So China make a mistake of not showing up at the South China Sea by not appearing or challenging the jurisdiction outside US court at international political level. Do you think there would be any possibility of China agreeing to some kind of a negotiation settlement with the US?
Interesting. So, I think we probably covered some of that after the question came in. And hi, Johannes, one of my favorite legal academics in Hong Kong and a brilliant lawyer. So I always feel overmatched by his questions. But I think if one wants to be very lawyerly about this, there's a way of approaching it, which is, of course, you can show up and challenge jurisdiction and not concede the rest of the case. But it's politically very tough to do. And I think the lesson of you've just frozen on my screen. Can you still hear me?
Yeah.
Okay. Sorry. So I think I think as we're saying, that the politics of it are very difficult, and it's really a tough choice that China would have to make. Of does one wait this out in the hopes that it's just going to go away because these are so silly? It's very hard to do if you're not showing up, because there is a risk of a default judgment. If you show up to challenge jurisdiction, that lends a certain legitimacy. If you decide to fight beyond jurisdiction, where I think you'd have a pretty good case because a lot of these claims are real stretches, then you might ultimately prevail. Do you try to work the diplomatic channel, because there is some discretion on things like active state that might dispose of some of these claims? So it's a very complex matrix. My lawyer friends in China, a lot of them get this and understand, but just to take the South China Sea example again, there was, as I understand it, a significant debate inside China about whether China should show up, kind of like the US Nicaragua case and the ICJ over the Contra stuff back in the 80s, that China should show up and deal with jurisdiction and then absent itself from the merits. That's a lawyerly view. People at the Ministry of Foreign Affairs, as I understand it, said, no, it's above the lawyer's pay grade. So I think ultimately, for something this sensitive, it's not going to be the extremely able lawyers like Johannes Chan and his mainland counterparts who are making the call. It's going to be a political call. And there, I think the pressure to just sort of express outrage and not partake is going to be pretty heavy.
Right, I see. And actually, I saw another familiar name in our Q&A, and it's actually coming from Hualing Fu, my dean. So I guess because he's the dean, I have to ask his questions. So Hualing
Another old friend. Hi, Hualing.
So Hualing asked, the litigation is part of a larger momentum in the Sino-US relations. If you step back from the cases and look at the larger picture, what do you see?
Well, I pretty much we've been discussing, which is I think it's bad. I don't think it's irredeemably bad, but it's as bad as I've seen it in the 40 years or so that I've been paying attention to it, 40 plus years. I think it, there are inevitable bad parts of it, ranging from long emerging economic conflicts, conflicts of strategic interests, power gap closing, and an increasingly ideational conflict as China moves farther away from everybody can follow his own path to suggesting there's a Chinese model. So on all the fronts that usually cause friction, this is up considerably. The thing that gives me some glimmer of hope is that there's a lot of ballast there over 40 years. It'd be very costly, and people talk about decoupling. That would be done around the margins. To do it on a large scale is pretty much unimaginable. So the notion that there are conflicts of interest, but not, I would say, profound conflicts that both sides consider 核心利益 as their core interests, and that there are reasons to muddle through, means that overall, again, a really bad stretch in a downward trend line, but I hope and think we're not headed for a catastrophe. Of course, since nobody from the US can travel to China or from China to the US these days, who knows what that means for either conflict or communication.
Right. I was scrolling down the question list and I realized I have to ask a question from the external audience rather than from my colleagues. Otherwise, there will be a protest.
Otherwise, it feels like lunch at the senior common room at HKU.
Yeah, exactly. So this is from Albert Lee. I don't know about his affiliation, and he asked, how would the court in the US to ensure evidence to be ascertained, as many documents will be classified as confidential due to state security? Also, how would the court summons witnesses from China or other overseas organizations?
Yeah, no, that is really tough stuff, and it comes up quite frequently. And I don't think there's any practical way to get this, and so that's going to be one of the issues that would bedevil these cases if they went forward. So you see some preparation for that risk in the way the complaints have been pled. That is, they try to make their argument essentially in the form of, from what we know in the public record and from what Chinese official sources have said, or what the WHO has said. Basically, they're trying to get either admissions by the party on the other side, China and the various actors, or things of which a court might almost take judicial notice, so they don't have to get into that kind of evidence. And that's the clever move from the plaintiffs. But if you go into what the tort doctrine is actually going to require here, in a lot of cases, it's going to be a tough question about whether what's in those kinds of sources is going to be enough. Now, if China wants to sort of defend against those things, it's going to be hard to defend in the form of saying, well, I can tell you, but I can't tell you. That the evidence is there with the state secret. Evidence in transnational litigation that crosses the US and China is constantly an issue. It's often a factor in forum nonconvenience motions. One of the reasons US courts send cases back to China is because the evidence is there and there's no great way to get the witnesses here or to conduct a deposition in China for use in US courts. There's just all these impediments to evidence gathering that exist even in unpolitical cases. And when you throw in this stuff, it just becomes unimaginable and intractable.
Right, I see. Okay, so I have a question from Ling Bing. I don't know whether this is the Ling Bing you and I know.
That's what it is.
Well, because he didn't indicate affiliation, but we do know there's a well-known professor called Ling Bing. And then the question is, hi Jack, what is the prospect of US congressional investigation of China's handling of the coronavirus?
Well, if Congress can ever do anything other than pass stimulus bills and try to investigate the Trump scandals, I would think there'd be a fairly high chance. I mean, especially if the Republicans remain in control of the Senate. I don't know if much is going to. The short answer is that whatever Congress is going to do in the near term is really dependent on it not being all coronavirus in the US all the time, and is going to be dependent on anything politically charged like this, either turning out to be a dead end, investigating what's going on in various executive branch agencies, or a sense that the coronavirus hearings would be helpful to a political agenda. So I could see the Republicans doing it in the Senate. I think for the Democrats to do it in the House, it would be a tough calculation. It would be kind of like we were talking about earlier. What do you do? It's a bash China atmosphere, sincere or pretextual, but the Democrats don't really gain anything politically by going too far down that path, lest they play into the Republican blame China, not the Trump administration hands. But I would be surprised if there weren't some kind of hearing somewhere down the road, if for no other reason than at some point, I assume there will be a congressional inquiry into why the US response to coronavirus was so bad. And that's going to very quickly get you into this game of figuring out China's role in the outbreak.
Right. I saw there was a question from Yang Wenlan.
Someone I don't know.
Someone we don't know. and show my impartiality in choosing the Q&A. So he asked a question that was quite interesting. He was wondering how far the lawsuits against the Chinese Communist Party and the Chinese research institutions, the Chinese Academy of Science and the Wuhan Institute of Virology, how would these cases go? I mean, because I think they were part of named defendants in the lawsuit. Would they also be covered by the sovereign immunity?
So Chinese Communist Party, as I said earlier, clearly not. It's not a state entity, it's a political party, but there's a court skepticism toward doing an end run around the Foreign Sovereign Immunities Act by saying, all those state actions they're really the parties doing. That's a tough sell, and even on the most sort of critical versions of Chinese politics, it's going to be tough under U.S. law to say the party and the state are so much exactly the same thing as opposed to the party dominating the state. That's going to be tough. As for CAS and the Wuhan Institute of Virology, they are most likely going to be treated as state instrumentalities. I mean, it's a little tricky. There would be litigation over what exactly the status of the lab is and things like that, but these are often going to be considered state organs. But there would be litigation about that. And if they're not state organs, if they are deemed to be separate enough that they're kind of like state-owned enterprises, then in the US view, if they're directly owned by the state, they still get sovereign immunity. If they're indirectly owned, then they don't get sovereign immunity. It's the Dole case. So could go either way, and I haven't looked enough into the details of their relationship, but I would say first cut, the argument would be that they are part of the state, and then we litigate over whether that was in fact true.
Right. One of the audience question is asking whether there will be any recording of today's webinar, and I can answer that one. And yes, there will be recording, and we're trying to make it publicly available on our faculty's website. And to those audience that have registered, we should be able to send you an email with a link to the webinar recording. And I know that it's almost midnight at Jack's end, and we will have to let the Cinderella go home before midnight. And I really appreciate that you spent so much time with us today, and especially staying up so late. And I'm sure the audience are also very happy with all your answers. And I think it tells us a lot about things that are going on right now. So thank you. Thank everyone for participating today. And we hope that you can come and join our webinar at the University of Hong Kong in the future. Thank you, everybody.
Thank you.
Bye.